Gentlemen,
Can I please have your attention? Can you dig it?
Greetings, dear listeners. This is Jonah Goldberg. You're listening to the Remnant podcast brought to you by the Dispatch and Dispatch Media. I can't say I'm exactly happy to be home, but I am home. It's been kind of a whirlwind adventure the last 3 weeks. And we have a somewhat of a special episode today. Andy McCarthy, who's the chief legal poobah at National Review and a former special prosecutor who put the blind sheik behind bars, is also a legal commentator for Fox News. And I will just say up front, because I think it's important for listeners to understand this, I consider him a dear friend. And while I've often had disagreements at the margins one way or other with Andy, I've always respected Andy I think he always approaches things in good faith. And one of the reasons why he wanted to come on is he's been getting a lot of brickbacks from people who think he's taking a position not in good faith, which I'm just going to reject up front. I've just known Andy too long and seen him take positions that have earned him grief from all parties to think that he doesn't come to this stuff naturally. Doesn't mean he's not necessarily wrong, but that remains to be seen. And since I'm not a lawyer, he will probably be able to steamroll over me anyway. But he has to come on so he could sort of address some of the controversies. I was glad to have him on for any reason. And so here we go. Andy McCarthy, welcome to the Remnant. Welcome back to the Remnant.
Jonah, it's great to be here. And if I steamroll over you, I'll be the first. So that'll be great.
I'm not sure that's true, but we'd have to hit the archives. And we don't want to talk about episode 11. Now, normally I'm an avid listener of the McCarthy Report, the podcast you do with Rich Lowry, where you graciously give Rich equal credit for the content of that, when in fact he just basically asks you questions. But you always begin with a lot of inside baseball about baseball for the most part, and occasionally football. We're not going to do that here today. But I want to know, you had this tragedy with your Saint Bernard, and I just want to know if you have gotten another dog, or are you still dogless?
We're still dogless, but I think mainly because we've had stuff going on, like my younger son going away to school, and he's playing ball where he's at school. So we're traveling back and forth. So I think between the sort of the grief of this, which is something I never in my life anticipated going through, but was really a lot more than I bargained for. I think by the time we felt like we had that far enough in the rearview mirror to think about it again, it was a situation where it wouldn't have been fair to the dog, but we're still likely to do it. We've been spending a lot of time in Chicago, where it looks to me like everybody has two dogs. And they're hardy people, man. I mean, they're out there. It's it's 10 below zero, and they're out, walking the walk and doing all the things you have to do. So,
and it's also climate well suited to getting another Saint Bernard, just for the record.
Yeah.
But anyway, all right. So why don't we do this straightforwardly? Let's just so Donald Trump's been indicted. There are four indictments, or four charges, whatever.
4 charges, right?
Why don't you just sort of give us a broad outline of how you see it?
I had always hoped that Smith, who was a special counsel, would take advantage of that fact, which makes him unusual among prosecutors, because they can write a final report.
Mm-hmm.
Like when I was a prosecutor, when we were done with a case, you close the case and move on to the next case. Special counsel always in the end writes a report for the attorney general, comprehensively laying out what happened in the investigation. That is usually something that you're not supposed to do, because the Justice Department frowns on speaking publicly about the evidence against uncharged people. But special counsels only get brought in when there's public corruption or public wrongdoing. So it's appropriate in those kind of cases, in a way that it isn't, I think, in the normal case, to lay out a narrative report that says what the prosecutor found. And I think it would have been valuable to have a record from a Justice Department prosecutor after an investigation, because I think it would have had more credibility than, say, the January 6th committee did, because that was fraught with politics in the way it was structured. Obviously, there's some people who would say it's a Biden Justice Department prosecutor, and I would certainly have wanted to look at it closely. But I don't have a quarrel, and I don't think anybody should, with the factual recitation that Smith has in the indictment, which I think is very compelling and to my mind lays out in a way that hadn't been laid out before with a lot of credibility the bad behavior that went on from election day forward, for which I think Trump should have been impeached. And my beef at the time with the impeachment was that I thought they charged it wrong. And I was particularly sensitive to this because I never did an insurrection case. I don't think we've done an insurrection case for a long time. But I did do the next closest thing, which was seditious conspiracy. And I was one of the few prosecutors in the United States to actually convict somebody of incitement, which is the federal crime of soliciting crimes of violence. So at the time of the impeachment article, I thought it was a real mistake. I also thought it was politicized, but whether I'm right about that or not, it was a mistake to charge him with incitement to insurrection because there were legal problems with both aspects of that. Whereas if they had done a thorough investigation of the kind that the January 6th committee did and had then accurately charged him with the plethora of things that were impeachable offenses from election day forward, that would have been a very strong impeachment case. And I don't know if politically they could have gotten it over the finish line in the Senate, but they would have had a better chance. I thought it was a cop out by the Republican senators to claim that they should vote to acquit him because it was somehow constitutionally infirm to have an impeachment proceeding against a guy who was no longer in office. I don't think that is tenable. So my beef is not with the layout of the conduct, nor with the proposition that Trump is not it should have been disqualified from seeking office again the way that you're supposed to disqualify someone in the system. And that I think this kind of gets to my main point, which is it's obvious from this indictment that Smith is groping for a charge that fits the conduct that he has laid out without difficulty. And he hasn't been able to do that. So he has to stretch these statutes in ways we can talk about. But what I've been trying to stress to people is it's not an accident that that's the case. We've had a Congress and lots of presidential elections now, nearly a quarter of a millennium. And yet we've never had an array of criminal offenses that apply, strictly speaking, to elections in the way that he needs to have charges that do that. That is not a bug. That's a feature of the system because we don't want the Justice Department and the FBI and investigators and the criminal justice system generally involved in elections unless it's absolutely necessary for them to be involved in elections. Principally, in the system, the check on presidential misconduct is the legislature and the voters, not the prosecutors. And obviously, the framers were a sophisticated enough group of people that they wouldn't have thought, even if you had something like the Justice Department at the time of the founding, which you didn't, but they would never have thought that a president could be checked by prosecutors who were subordinates of the president. So I think what Smith has done here is crashed into a structural part of the system. And the fact that he doesn't have an easy charge available for this obviously despicable conduct is not an accident. It's not like somebody forgot to pass these kinds of laws. So in order to make this fly, he has to find some kind of a legal rubric to bring this under. And essentially, he has come up with three. One is fraud on the United States, which is essentially fraud on the government. The second one is obstruction of Congress, which has to be corrupt under federal law for reasons we can talk about. And then I think he came up at the end, it seems to me, based on the reporting and other things I've seen, I think realizing that he could run into problems with fraud and obstruction because they're hot numbers in the courts, he came up with a third theory at the end, which is that Trump's behavior deprived voters or schemed to deprive voters of their civil rights, specifically the right to vote. And he brought that under a Civil War era civil rights statute that was initially enacted in order to go after the Ku Klux Klan, preventing Black Americans from voting in the Reconstruction period. And I don't mean to say that it's been completely confined to that kind of situation. It's obviously been extended. But I think this is extending it here is a bridge way further than not only what the statute initially meant, but what this current textualist Supreme Court would indulge. So I think he's got legal problems with all three theories. And I have been arguing since, going back a couple of years, that if you could not tie Trump to the violence of the Capitol riot in an actionable way. Now, I'm not talking about moral culpability or political culpability. I think we should all agree that he's got that in spades. But, and again, I guess this goes back to my, seditious conspiracy prosecution. If you don't have proof beyond a reasonable doubt of an intent that force would be applied or that violence would be done, you don't have a Capitol riot case. And I think the Capitol riot's the driver here. I think actually the things that Smith has said, including in the press conference right after the indictment, demonstrate that the Capitol riot is the prism that he hopes the jury that he'll be able to present this case through that prism, even though he hasn't charged him with the Capitol riot. So I've been pretty adamant. This is not it shouldn't be a surprise to anyone who cares what I think. That if you can't get Trump on the violence, I thought it was a mistake to go after him on these other things, because it then becomes a sort of a criminalization of the electoral process. I'm not saying that what Trump did here was appropriate to the electoral process, but you get into the area where we don't want law enforcement deciding elections. And that's what we have. And I guess I'd finish with when Barr said in connection with the Russiagate investigation that he had Durham do, when people were clamoring for, when are the charges coming? When are we going to get the big RICO on Jim Comey and Hillary Clinton and all these other things? Barr said, and I continue to think this was right, that unless you have a meat and potatoes crime, which is to say a crime that's very serious and very easy to understand and that you can prove by convincing evidence, then you don't want the Justice Department getting involved in the electoral process. And I think that's what we have instead.
Okay, so there's a lot in there. Some I agree with entirely, some I agree with partially, some I'm going to push back on. Let me sort of start with the part where I think we largely agree, though I'm not entirely sure that at the margins we might have some disagreements. The impeachment process is broken, right? And it's broken for all sorts of reasons. I think a healthy republic where, the one thing which I've said about it a zillion times on here, the one place where the founding fathers obviously got something wrong was in thinking that our different branches of government would forever and eternally be zealous guardians of their own prerogatives.
Yes.
And I think we can both agree that Congress has washed its hands of all sorts of responsibilities. And even your point about creating a Justice Department is one example of that. It's not the best one, but it's a good example of it because it's not in the Constitution. They created this thing, and then the political oomph for doing serious investigations for political misconduct leave Congress and go get sort of legalized and criminalized and bureaucratized with the Justice Department. And I personally think that first of all, I think a healthy republic would have impeached and removed Trump within 48 hours of the Capitol riots. I don't think it would be a close call. And I tend to agree with you that the charge of dereliction of duty is probably would have been the strongest thing to impeach Trump on, that he just sat there while Congress was being attacked. But the mere fact, I've always said that the violence is almost ancillary, because merely sending a mob to protest Congress is something that should rightfully have pissed off Congress to the point where they say, what the hell are you doing here? Right. And they didn't do that. So like, Congress has been gelded. Republicans and Democrats alike didn't want to have witnesses in either impeachment. The January 6th committee was essentially an impeachment hearings after the fact. It was just, they got everything cattywampus and ass backwards and all that. So that's all set and fine. Where I think I want to push back sort of the most before we get to the specific legal argument stuff is, and I know this is and you're free to correct me on any time I'm mischaracterizing you, but you make this point often on your podcast with Rich about how this is essentially a political impeachment, or a political investigation. And broadly speaking, I'm sympathetic to that, right? I mean, it's like the second you decide to appoint Jack Smith, is the point Bill Barr has made, that the second you decided to name Jack Smith, you were probably going to get charges, because that was a decision to make. And that was a decision he was going to make. And where I don't want to reduce it simply to a who started it kind of thing. But if you're talking about criminalizing the electoral process, it seems to me that Donald Trump is the guy who did that, right? By criminally trying to use the Justice Department to lie and essentially steal an election. And that seems to me to be that is the prime mover. That is the first mover in this entire spectacle. And so when people like you and others say that the decision to prosecute Trump is a political decision, the decision not to prosecute Trump would also be a political decision. You can't get out of politics at this point, because, like we always hear people say, oh, we can't have a two-tier system and we can't have different rules for different, for presidents and stuff. But we have different rules for politicians. The Justice Department is much more reluctant normally to go after politicians if they don't have just a drop dead cinch of a case, right? They don't have the same reluctance, for understandable reasons, about some car dealership that lies about its VIN numbers or something, just because there's so many political stakes involved. And so anyway, I think this process has been corrupted by politics, by the misdeeds, crimes, acts of Donald Trump. And then to fall back and say, well, the system can't respond to this truly, sui generis, bad facts make for bad law kind of misdeed, because that would be politicizing things, kind of lets Trump off by a standard that he wasn't willing to follow for himself.
I think the disconnect there is, even if it was a political decision, and unavoidably a political decision, to prosecute him, and I want to drop back to why I think Smith's appointment is a key part of the politics here. But even if it was a rife with politics, no matter what decision you made, you would still have the problem of whether there's an obvious crime or not.
Sure. Yeah.
So that if you had as I said at the beginning, if you could tie Trump actionably to the Capitol riot, I would support his criminal prosecution under any circumstances, because I think that would be a clear violation of law that was epically important and that couldn't be overlooked, and that should be prosecuted. And would it be fraught with politics? Every political corruption case, and I've been in a bunch of them, is fraught with politics. So when I talk about politics, what I think, for the most part, I'm running this through the system as I'm saying it, but I think for the most part, what I mean is the prudential idea that you want to keep the prosecutors out of the electoral politics. It's not a hard and fast rule that it can never that you should never indict. I accept and concede that if there's a very serious crime that you have convincing evidence about, you should indict. Now, there's fraught with politics by nature, and then there's fraught with politics that's injected. So, for example, the only time you're supposed to have a special counsel is if there's not only something serious to investigate and prosecute, but if there's a conflict of interest that's inherent between the prosecutors and the defense. So the common situation is like, Valerie Plame, where you would have the Bush administration or the Bush Justice Department investigating the executive branch, where you would commonly get a special counsel. Here, there was no conflict of interest between the Biden Justice Department and Trump. In fact, they were investigating Trump for 18 months before they named Smith. So I thought it was obvious that they brought Smith in because Biden knew that Trump was going to claim in connection with the campaign that Biden was weaponizing the Justice Department against Trump. So they came up with this fiction of a special counsel in order to pretend that Biden and Garland don't have anything to do with the prosecution of Trump, when in fact Smith is exercising Biden's power and he reports to Garland. So I thought that was a political construct at the beginning. And then the other night, when he announces his charges, he talks for 3 minutes, and 2.5 minutes is about the Capitol riot, which is not a charge in the case. And then if you flip through the indictment, at the very end, I want to say like page 39 of a 45-page indictment, he throws in some paragraphs about the Capitol riot, even though he's not alleging that Trump intended the Capitol riot to happen or that he had any actionable connection to it. And indeed, he has to take that position, I would think, because the Justice Department's done like either 1,000 or 1,100 of these cases, and they have never taken the position that Trump was an unindicted co-conspirator, that he was complicit in the violence. And they've actually fought against defendants trying to shift blame from themselves to Trump. The seditious conspiracy cases they brought, which I didn't think they should bring because it seemed to me that the only way that you could prove this case on the up and up was to say that these people thought that they were acting at the direction of the president, which means you can't, by definition, be at war with the United States, which is, what seditious conspiracy is supposed to be about. The way the Justice Department tootled around that was to, in the four corners of the seditious conspiracy cases, they indulged the fiction that Trump is a side issue. Basically, they said Trump was a pretext that was that these violent defendants used as a reason to rationalize something that they were going to do anyway, like do a violent attack on the Capitol. So I see a lot of gratuitous politics in this through and through. But even if that were not the case, even if everybody, even if we were just dealing with the situation that you just described, which is that you have a situation that no matter which way you go, it's fraught with politics. I guess I still come back to the problem of, do you have a clear enough crime? And I suppose that, the big difference between me and the people who are arguing the other end of this is that they think that there's a perfectly good crime simply because there's perfectly despicable evidence. And what I'm saying is that's not always the case. A lot of times there are very bad things that simply aren't criminal. My favorite, I guess this goes back to like old philosophy class days back when, right? But I've always been interested in the philosopher's fallacy, that a phenomenon is just simply is, or takes on the aspect of the thing that you measure it with. And I think in this instance, and in a lot of instances, actually, we kind of get to this ridiculous place where unless you can prosecute something under the criminal law, it's not really wrong or it's not really bad. And there are a lot of things that are horrific that can't be reached by the criminal law for a lot of good reasons. I happen to think this is one of them. It's certainly not one that's easily reached by the criminal law. I think even people who champion this case in a way that I think, I come out on the other end of it, I think they will concede that this is not a layup in the Court of Appeals, that they're going to get a lot of pushback from the higher courts if it gets to that point, which I think it will. So my beef is with all my political objections and all that crap. I'd lay them on the side if there was a serious crime, but I think there's serious misbehavior. That doesn't mean there's a serious crime that applies.
Okay, so I want to get to the actual specific charges.
Yep.
in your contention that they're a mismatch. But you bring up the seditious conspiracy thing, and it's worth noting that you thought you couldn't bring a seditious conspiracy case for understandable, colorable, plausible reasons, and yet the Justice Department successfully convicted some guys, oath keepers, on seditious conspiracy. And so I think that part of the question here is, like, simply because you think they're bad arguments or tough arguments or not the arguments that you would bring, if the DOJ can successfully convince a jury that these are violations of law, I hate to make these kinds of arguments where it's illegal if courts and juries say it's illegal and that the black letter of the law doesn't matter and all that kinds of. But in a very practical sense, the black letter of the law doesn't, or your interpretation of it doesn't really matter if people can convince a jury that that the underlying conduct was so bad and close enough to what the law stipulates that they say, yeah, like, convict this guy, right? And
yeah, no, I think that's totally right. It could be. Look, number one, I can. It doesn't matter how much I think I'm right. Right. Somebody has to decide in the end. Whether it's the umpire, if the umpire behind home plate says the ball that's a foot and a half outside is a strike, it's a strike. In the end, it doesn't matter. And I could be wrong. For example, there's a prong of the seditious conspiracy statute. Seditious conspiracy statute targets like 4 different kinds of behavior. And the main line of it is conspiracy to levy war against the United States. There's also more minor prongs of it that talk about conspiracy to use force against the government. And the Justice Department may very well be able to argue on appeal in a way that will convince the appellate court that even if I'm right, that the defendant should have been able to show that they thought that they were acting at the behest of the President of the United States, and therefore they couldn't be, by definition, they were not making war against the United States. They thought they were being, called into combat on behalf of the United States against the evil people who were stealing the election. The Justice Department may be able to defend this on the idea that, look, whoever they thought they were being loyal to, they agreed to use force against the Capitol, and then they used it. And that's a government installation, and that's enough. And they may end up being right about that. We'll see how the appeals come out. I try to continue to argue what I think is right, as long as there's still an opening to continue to make that argument. But I've also been wrong about stuff. I mean, I guess
not me.
But I mean, look, I argued passionately as a prosecutor that the wall that the Clinton Justice Department people put into place in the 1990s that prevented the intelligence side of the Justice Department's house from talking to the criminal side, right? I said that was a catastrophe, and that it should never be permitted to happen, and that their rationale for it was ridiculous. Namely, that if you didn't have a wall, then the government might abuse its national security, foreign counterintelligence powers pretextually to sit on someone when they didn't actually have criminal investigation or crimes that would justify a criminal investigation. And I said that would never, ever happen, because to use FISA, you have to go through a whole different channel in the government where there's different, sign-offs that you have to get. And it's precisely what happened. I said I thought that it was much better for us the way we were structured rather than the way the Brits were, where you had the foreign counterintelligence and the criminal missions all under the same roof where they could leverage each other. And now it looks to me like it's abusive. So, I was either wrong then or I'm wrong now, but one way or the other, you can't square the both things. So I don't pretend to be right. I like you, I do the best I can with the information that's available. And if I turn out to, if they rule against me, sometimes they rule against me because, their arguments were better than mine. And sometimes they rule against me because they get to be last.
Right. I mean, I kind of think of it more like jury nullification, right? There's a tradition in America that sometimes somebody is guilty, but the extenuating circumstances or the unfairness of the law in general, or a whole bunch of things, because sometimes jury nullification is evil and sometimes jury nullification is righteous. But I think it's perfectly colorable that if Jack Smith can make a colorable argument on some of these charges in front of a jury where the defense makes a case that this isn't what the statute was intended for and blah 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 blah, the jury just says, look, but this was so terrible, this was so outside the norm, this was such a act of violence, rhetorical, literal, figurative, whatever, against the constitutional order, that these are the tools we've been given and could, with a clear conscience, vote to convict. And and part of the disadvantage that both of us have right now is we actually don't have access to the evidence that Jack Smith hasn't shared with anybody, right? So there could be facts, conversations, transcripts, depositions. I want to talk about it in a little bit, but I think Mark Meadows is probably cooperating. There could be sort of smoking gun evidence that makes some of these claims even more plausible, more colorable, whatever. And we can get to that. All right. So, but let's just go through it. Explain that your primary objection with the defrauded the U.S. government charge.
Okay. And before I do that, I just want to say that the thing that you laid out just now is not only possible, it's probable. I've never seen a case where the prosecutors didn't have something that wasn't in the indictment, and they are you do continue to investigate up to and through the trial.
And you also could be flipping some of these unindicted conspirators.
Correct.
And that changes the whole ballgame.
I think the possibility that you just laid out will be more of a thing with respect to the obstruction counts than the other counts. So I know we're going to go through this now, but I think that's a stronger argument with respect to the middle two, which are really the same thing. It's a obstruction and a conspiracy to obstruct. Here's the thing with the fraud. The Supreme Court in May decided two cases that are not on the fraud statute that is charged in this case, and I should explain that. The fraud statute that's charged in this case is conspiracy to defraud the United States under a section of the Penal Code known as 371. There are a variety of fraud statutes in federal law. The ones that are most commonly brought are mail fraud and wire fraud, 1341 and 1343, I think. And then there's another fraud count that I'm going to want to talk about, which is a conspiracy to defraud a government-funded program run by the state, which will be important for reasons I'll come to. So you have this complex situation where you have one concept, which is fraud, and it is expressed and applied in a variety of different statutes. And what it comes down to, Jonah, in the end, is I think what the Supreme Court is saying pointedly to prosecutors is that fraud is fraud is fraud. That no matter what statute you're talking about, the concept of fraud in federal law is the same unless Congress redefines it, which it has not successfully done. And the people who disagree with me instead argue that 371 is a more sweeping fraud statute, and that more importantly, there are cases from the Supreme Court from 1910 till about 1924, which expanded the concept of fraud from what I say and what the modern Supreme Court says it is, which is a deceptive scheme to bilk a victim out of money or property. The other side of the argument says these 1910 and 1924 cases, the first was called, I think, Hankel, and the second is called Hammerschmidt. Hammerschmidt is written by William Howard Taft, actually, in 1924. But those cases stand for the proposition that a scheme to defraud the government includes not only trying to bilk the government out of money or property, but expands to any deceptive scheme that would undermine an essential function of government. So the rap on that for years has always been that it, number one, defies the basic tenet of the criminal law that a statute, a criminal statute, as opposed to other kinds of statutes, a criminal statute has to be sufficiently clear that a person of average intelligence knows what the law prohibits. Because that expansive idea of fraud essentially allows prosecutors to write new crimes based on deceptive schemes that they find that don't necessarily involve money or property. To take an example, they invoked the 371 conspiracy against Manafort in the Mueller investigation. So they charged him with conspiracy to defraud the government, not on the basis of trying to steal money or property, but because his willful failure to register as a foreign agent, along with other people who were involved in the same activity, undermined the government's ability to maintain a comprehensive registry of foreign agents. Now, the problem the prosecutors had there is Congress hasn't written a statute that makes it a crime to conspire to violate FARA, which is the Foreign Agent Registrations Act. So to try to get around that, they used this catch-all conspiracy to defraud the United States and essentially wrote a crime that Congress had never codified. And what the Supreme Court has said about fraud in the recent cases is two things. One is when fraud was initially put in the federal code, which happened in about 1870, the common understanding of fraud was that it was a financial crime, that it was a scheme to steal money or property, and that courts and prosecutors over time took liberties with the concept of fraud and stretched it to cover other things that were not financial crimes. And I would say that these two Supreme Court cases from 1910 and 1924 are of a piece with that, but they're hardly alone. So with respect to all the other fraud statutes, you got all kinds of theories of extending fraud to cover things that were not financial crimes and that were basically designed to impose somebody's idea of what good government looks like. A lot of them came up in the political context. You know, you get as Scalia has laid this out in a couple of opinions, but basically there were like 6 or 7 different theories of fraud floating around. A lot of them were of the nature of a scheme to defraud people out of honest services, like this idea that certain people, mainly public officials, but not exclusively, owed a fiduciary duty of truthfulness and good behavior to some people who were not always clearly defined, which is part of the vagueness problem of this theory. So there were 6 or 7 theories floating around that tried to extend the idea of fraud beyond a financial crime to other kinds of bad behavior. And in 1987, the Supreme Court decides a case called McNally. in which they say emphatically fraud. Now, I should stop and say McNally came up under the wire fraud statute, I believe, we're not talking about the conspiracy to defraud the United States statute. But the court says fraud is a financial crime. It's a scheme to steal money or tangible property, nothing else. And they throw out the conviction. And in dissent, Justice Stevens says, wait a minute, it's too late in the day to take that position, because we said in these cases in 1910 and 1924 that fraud extends to all these other theories beyond financial crime. And it doesn't make any intellectual sense to have a different definition of fraud for purposes of, like, say, the wire fraud statute than the statute that prescribes conspiracy to defraud the United States. He's right, or he was right, about the fact that it doesn't make any sense to have a different definition. But his problem is he's in the minority. And the court is being very clear that it will not indulge a fraud theory that isn't confined to a scheme to steal money or property. Now, the comeback against me for saying that, no matter how many times the court says it, is that you have these cases from 1910 and 1924 that apply to this specific statute that is actually cited in this case, and that all the cases where the court has slapped back at the government for extravagant fraud theories are not that statute. They're mail fraud or wire fraud. So, for example, Jonah, in the Bridgegate case, one of the big charges in Bridgegate was conspiracy. Everybody remembers Bridgegate was, they shut down the Fort Lee lanes of the George Washington Bridge and caused them 4 days of traffic jams and all that stuff. So in the Bridgegate case, the government charged conspiracy to defraud not the government, but a government-funded government program, state government program. So the court said, no, fraud is a financial crime. It's stealing money or property. And to the extent that that what the fraud in that case was about was to manipulate the government's regulatory power in order to do the damage that was done there, Justice Kagan, who is like following, even though she's a progressive on the court, she has bought onto the Scalia textualist theory that, it is what it was understood to be at the time it was enacted. What she says is, we've said in prior cases, and she's right about this, that the government's regulatory power and to do things that are deceptive in order to manipulate a regulatory function of government is not a property interest. So it's not cognizable under the fraud statute. So I'm very comfortable, even though I have a lot of respect for the people who disagree with me on this, I'm very comfortable taking the position that it's not tenable to have a different definition of fraud for conspiracy to defraud the government than the definition of fraud that you use in conspiracy to defraud a government underwritten state government program. I just don't understand how it could possibly be a different definition. And I just think that in May, as late as May, the court decided 2 cases, the Cuomo crony cases, where they threw out public corruption convictions and emphatically said 2 things. 1, fraud is a financial crime. And 2, the reason that we have construed it that way is because the way separation of powers works, if Congress wants to write a statute where they expand the definition of fraud, and they can do it with clarity, the problem they've had up till now is vagueness, but if they do it with clarity, then we'll uphold it. But prosecutors can't use the fraud statute to write new crimes.
Okay, so I have 2 forms of pushback. One is the one I've read in lots of places.
Yep.
And one is my own not lawyerly thing, which is, it seems to me that I'll start with the not lawyerly one. It seems to me that if you can be sent to jail for stealing money from a pension fund, stealing money from stealing pens from the office supply closet, go down the list, because these are things of value, trying to corruptly steal an office that you've actually made money from strikes me as within the ballpark of trying to steal something. And Trump, who monetized the White presidency or just his salary, clearly the presidency is a thing of value, tried to steal it outside of the proper functioning of government, outside of the rules and all those kinds of things. I understand that may fall outside the way statutes are written. I get it. The other argument you hear from a lot of places is that, again, this form of defrauding the government has been tried more recently than 100 years ago successfully in one way or another. And that when Clarence Thomas, in the thing that you cite, says, fraud means fraud and all of that, nowhere in his opinion or in any decision from the Supreme Court did it say, oh, and by the way, our decision renders null and void using this other understanding of defrauding the government in lower court cases. Doesn't normally, when the Supreme Court declares this is what we mean and this is how the lower court should behave, doesn't it say, and therefore you can't do this anymore, which they apparently have not done? Thomas does not mention Section 371 anywhere in there, nor does anybody else.
No, it would have been improper to mention it because it wasn't before the court. And you're quite right that there's a doctrine of law that disfavors overruling things by implication.
Mm-hmm.
That doesn't mean that they're not overruled by implication, but you have to litigate it. And what I'm saying is, if I were a boss in the U.S. Attorney's Office and one of my subordinates brought me an indictment like Jack Smith's indictment, what I would have said was, you can't indict this into the teeth of what they just did in May, where they told us not to do this kind of thing. And the pushback I would get is, but this is a different fraud statute. And what I would come back and say, I guess, is, well, it's a different fraud statute under circumstances where the Supreme Court now about 15 times has said fraud is fraud. And secondly, in the Bridgegate case, where there's a statute that I think is virtually indistinguishable from fraud on the government, you have one of the most progressive judges on the court writing the decision. And what she says is, the kind of behavior that you want to criminalize here goes to the government's regulatory function and undermining it. Here, the function we're talking about is Congress, or I guess Congress, Smith says certifying. I prefer the term ratifying, but what they were doing on January 6th, which was to count the votes and acknowledge Biden's victory. What I think the court is clearly saying is that kind of thing does not sound in property, and that if you don't have property, you don't have fraud. Now, I could end up being wrong about this. I think here's what I think will happen with this, Jonah, just for what it's worth. I think they're going to litigate this in front of Judge Chutkan. Smith got a very good draw in the District of Columbia District Court. Unlike the Mar-a-Lago case, I don't see any good reason in this case to depart from the usual rule that the whole case is supposed to be litigated and tried before the lower court before it goes up on appeal. And I think that Judge Chutkan will be very open to the arguments that I've disagreed with, and will say, look, all those cases, those are mail fraud and wire fraud and other kinds of fraud cases. They're not under this statute. And unless and until the Supreme Court throws out that statute on this theory, I'm going to assume that it's still sound. And he may very well get convicted on this, and then it goes up. And, going to the point that you made earlier about, somebody has to be the final arbiter of all this, right? It'll be a very interesting political overlay if that happens, because I think if this case went up on appeal before trial, which Trump will try to have happen, you might get one kind of hearing from the court. But if it goes up after trial and he's been convicted, and then the question before the Supreme Court is, are you really going to throw out Trump's conviction? I think that Chief Justice Roberts and Kavanaugh and maybe a couple of other conservatives have a big problem with that.
Yeah. And again, that gets again to my point, is that this is such a unique circumstance where Trump, and this is a story told many times over the last 5 years, where Trump is so contemptuous or disdainful of norms, rules, best practices, laws, a whole bunch of things that it's kind of like this passive aggressive thing where he forces other institutions to go out to color outside of the lines to deal with it. And this is a point I've been trying to make to my friends on the left many times, which is that like one of the worst things about when you have one major political actor violating norms is it gives other political actors permission, psychological, political, institutional, to violate norms in response. And then you just get this tit for tat thing that is a mess all over the place. And so again, I would rather this whole problem had been nipped in the bud by Trump not getting the nomination.
Right.
Right. Or then Trump, losing to Hillary, gives me agita, but you get the point. Certainly, I was in favor of both impeachments. There were exit ramps many times in the past here, including not nominating him again. But the prospect of having someone who's literally now vowing retribution as a high principle of what his second presidency would be about creates all sorts of knock-on catastrophic effects. And I could see the Supreme Court, if it had been Joe Schmo, then again, Joe Schmo wouldn't try to steal a presidential election, but you get the point. Supreme Court might be inclined to overturn it, but since this is such a clear one-off, I don't know that the Supreme Court would overturn a conviction on the grounds that you're laying out.
Yeah, well, that's what when you were talking before about jury nullification, my one quarrel with what you said about it is that jury nullification is not supposed to work both ways. We do permit jury nullification in our system to acquit someone. We don't permit jury nullification to convict someone.
Right.
So
that's a fair point. Yeah.
If somebody gets convicted because they're a bad guy, we expect that the appellate process is going to correct that at some point. But I think this is the unusual case where it may work in reverse, where like if he gets convicted, the Supreme Court, which has been made in the last decade, and particularly in the last, say, 5 years, to worry about these schemes to pack the court and these attacks on the court's legitimacy, I think it's a very big political ask. I know we're supposed to put politics on the side with that kind of litigation, but it's a big political ask if Trump has been convicted for the Supreme Court, even if they think that they did damage to the fraud doctrine. I think it'd be very hard for the Supreme Court to reverse a conviction of Trump if he's been convicted by a jury.
Since your contention is that the obstruction is basically the same argument, same facts, just
the two obstruction counts.
Yeah,
right. No, I think the issue there is just very quickly. This is being hotly litigated in the D.C. Circuit right now. We had a decision that came out in April, where it was a 3-judge panel, and they had 3 different opinions that went in. It was so hard. The opinions were in such disagreement that there's disagreement between the judges as to which opinion is the majority opinion. So the concept of what makes out obstruction of Congress is difficult because we're allowed to try to influence Congress. So what the court is grappling with is how do you come up with a rubric of obstruction that doesn't capture a lot of constitutionally protected activity? And one judge says, well, the statute requires the jury to find beyond a reasonable doubt that the person acted corruptly. And that corrupt usually means, morally depraved, blah, blah, blah. And that's enough. And then you have Greg Katsas on the other end, who's a very good judge, who says that, if you literally take what this statute seems to say, it captures all kinds of things like lobbying, for example. If you're a lobbyist for a bad cause, you could be convicted of obstruction under this statute on the most generous, expansive reading of it. So I think we may get clarification from the DC Circuit about what they think obstruction means. My beef with this from the beginning, for what it's worth, has been if you take the violence out. I think if Trump is involved in violence, there's no doubt that he committed, to my mind, there's no doubt that he committed obstruction. If you take the violence out, because they can't hang it on him, then basically what you're arguing is that John Eastman's legal theory, a frivolous legal theory is obstruction of Congress. Now, I think Smith would refine that, just to be fair to him, and say the fake elector scheme is a clear case of obstructing Congress, because the fake electors went to the extreme, not only of aping the kind of thing that you would do if you were the actual electors, but also sending certificates to Pence, which people would then use to argue that the case needed to be remanded. I think that version of the fake electors reads a lot better than it played at the time. I don't think on January 6th anybody really believed the fake electors were, if there hadn't been a Capitol riot, they would have laughed a fake the fake electors was such a non-thing that I don't think they would have been argued. But we'll see.
But it does go to intent, right? Which is,
yeah.
And so I think you're not signed on with this. There's a very popular, among Trump defenders, popular argument that this is just going to go to proving Trump's state of mind. It's impossible to prove Trump's state of mind. And that just strikes me as kind of preposterous, for want of a better word. But so how do you see that issue?
Yeah, I'm glad you asked me that, because there's two things that I want to separate myself from the arguments that I've heard, even including from people like Jonathan Turley, who I like. We go through this all the time. I mean, you prove people's intent by what they say and what they do. And the jury will get to hear all kinds of evidence on that. And it's a jury. The reason it's a jury question is they'll hear all kinds of evidence, and it'll be on Smith to, the problem that Smith has is he's the only one in the case has to prove anything, right? But I always thought, Jonah, in trying a lot of cases, that the minute, like Trump now says that he's going to litigate the whole thing of stop the steal, so he could show that he truly believed what he was saying. And he could try to do that. He's got subpoena power now. That's what the case gives him. But I always felt as a prosecutor that if the defense tried to prove something, that in the mind of the jury, they lost a lot of their advantage, that the government is the only one who bears a burden of truth. Because if they try to prove something, then it becomes your story against my story. And prosecutors, defense lawyers tend to be much better cross-examiners. Prosecutors are much better storytellers. They put cases together much better than defense lawyers do. And I always felt like I was in a good place if it came down to my story against their story. So I don't buy that stuff that you can't prove his intent. It'd be interesting if he testifies. I don't see, if he doesn't testify, I think he's clearly going to lose. And if he does testify, it'll matter how much of a good witness he is. And it's a little bit harder to be, he can be a bully in a normal conversation, but with a judge there, if she cracks the whip and controls her courtroom, might be a difficult experience for him. But we'll have to see. The other thing I just want to say, because I've heard this a million times, is this whole idea about how free speech is being criminalized. So this goes to what we were talking about at the beginning, between the difference between the legal and the prudential, right? I don't want to see the prosecutors in the electoral process, but now they're in it, right? So we're in the case. It's a doctrine of law that the First Amendment does not protect you from the use of speech as evidence. So like I did a million mafia cases where if the boss is in the back in the clubhouse with the other guys and he says whack him, I never once got a First Amendment defense for that, and that's because that's how we prove stuff. The First Amendment, what the First Amendment forbids is to make it a crime to utter words. And the only context I can think of where there's pushback on that is this idea of communicating classified information, where the actual utterance of the words is a crime. Other than that, as long as you're not criminalizing the utterance of words, you can use whatever people say in whatever context they say it to prove a crime, because you're not criminalizing the speech. You're proving the crime that's charged. And some people think that's a facile distinction. It's really not. I mean, it's a pretty principled distinction between saying it's criminal for you to utter these words and saying, if you utter these words, I can use them for whatever evidentiary value they have.
Right. And I think it's one of these things where partisanship is a hell of a drug, right? Because in 1,000 other contexts, the people who are saying this would be the first to acknowledge that the utterances of Hunter Biden in certain contexts were perfectly fine under the First Amendment, but that doesn't mean they're not evidence of corrupt scheming, right? Or Bill Clinton meeting with the Attorney General on the tarmac. It wasn't illegal for them to have a conversation, but what they were talking about, or unethical or whatever, but the content of the conversation is perfectly legitimate to go after. The thing that I find really kind of funny about the intent argument is that it's basically boiling down to the claim that Trump being deluded is a defense, right? Because you give all this evidence, 60 court rulings going against him, the testimony, the advice of his own attorney general, his own White House counsel, all these kinds of things, all these facts, 2 independent investigations that he paid for to try to prove this stuff, all the way down. They all come back and say this is all BS, and he refuses to agree with it. And so the argument is, but he just really believed it. Well, okay, but first of all, Trump has a long history of asserting things he doesn't believe to be true because he wants them to be true. But second of all, so your argument is that he was openly rejecting reality and therefore he did nothing wrong, which would be a great defense for a lot of serial killers who kill people because their German shepherds told them to. I mean, that can't be a defense in and of itself.
I think the way this works is the old divide between malum in se and malum prohibitum. Like, some things are evil because some things are wrong because they're inherently evil. Murder is, malum in se. The thing itself is evil. And then there are certain things that are illegal, like structuring financial transactions, so that you can't transfer more than $10,000 in cash without filling out a form, right? Those are things that we call them malum prohibitum. They're wrong only because we've decided to prohibit them. And I think the more esoteric an offense becomes in that area where it gets, where it's abstruse and there's a lot of legal rules and stuff, you have a stronger basis to say it was reasonable for me to rely on the advice of my lawyers. Whereas, when you're doing something that's really wrong, so look, if this comes down to, was it okay for him to rely on John Eastman's legal theory? He's going to be on sound footing more than if was it reasonable for me to maintain the conviction that I had won when everybody credible was telling me I lost. And the jury will be able to consider the fact that he lies all the time. So to the extent that he's saying that he really believed that, he's doing what he does, which is that, he doesn't tell the truth. And then they'll decide on the basis of all of that.
But also, on this John Eastman part, right? If you go to one lawyer after another and say, can I rob the bank because it's my money in the bank and I want to rob it? And every lawyer says, no, you can't. And then you finally find a lawyer who, let's just say, to strain the analogy a little bit, says, yes, you can if I get a cut.
I love this.
that doesn't make it you can't say I was relying on advice of counsel, right? And it seems to me that that's part of the strategy. You correct me if I'm wrong. You obviously know a lot more about this. That seems to be part of the strategy of making Eastman and Giuliani and these others co-conspirators, is that there is no attorney-client privilege. There is no relying on counsel privilege. If the counsel that you're relying on, rather than your attorney general and your White House counsel who tell you what you don't want to hear, but instead these people who tell you what you do want to hear, that advice counts for even less if legally you can demonstrate at one point or another that they were part of the illegal scheme, right?
That's right. Even if there's no what's called the crime fraud exception pierces the attorney-client privilege, and the crime fraud exception, we should note, is just, it's an evidentiary thing. And to split some legal hairs here, what I mean is you don't have to prove beyond a reasonable doubt that there was actually a crime. If a court finds that it's more probable than not that there was a crime that the client and the attorney were in on, or that at least the attorney was aiding and abetting in some way, then that's enough to pierce that. And you could tell that Smith isn't even worried about that, because he's laid out all these statements in the indictment, and I'm not sensing that there's pushback from Trump that his attorney-client privilege. I think that's going to be a big issue in the Mar-a-Lago case, but I don't think it's going to be much of an issue in this case. But if they're involved, then that's not going to be an issue at all. The one place, and I know you didn't mean it this way, but the one way I would push back at your example, which I otherwise found to be a very amusing example, especially since you don't have to worry about Mr. Green. He's right there in the middle of the thing. You can take it. You can't take advice. You can't say my lawyer told me it was okay to rob the bank. The issue here is going to be, was the interplay between the 12th Amendment and the Electoral Count Act as it existed before they amended it. Did it have sufficient play in the joints that constitutional law professor John Eastman had such gravitas in this particular esoteric area of the law that it made sense for Trump to listen to him when everybody else was telling him it was cockamamie? And I would just say he's on firmer ground with that kind of an argument than if Eastman had told him it was okay to rob the bank.
Fair enough. That's fair. I mean, although I will say just, and this is a shout out to your colleague, John McCormick, right? I think it was John who first asked John Eastman, so according to your theory, could Kamala Harris, if Joe Biden loses in 2024, just simply reject the electors and make Joe Biden president again? And Eastman, no, that's crazy. It kind of gets to the underlying sort of good faithness of John Eastman and all of this stuff, and how a lot of his arguments were probably pretextual. It wouldn't surprise me if that didn't come up at some point in Eastman's problems. Okay, let's move to the civil rights thing, just so we can. I said we we're going to go through all of them, and we haven't gotten to that one yet. So, what is your beef with this?
I just think that. So, as we said before, the civil rights statute is a post-Civil War statute. It was originally intended to deal with violence. If you look at the words of the statute, it talks about injure, intimidate, attack. There's a string that all the words are words that you would associate with violence. In the more freewheeling era of the Supreme Court, and what I mean is, I think Scalia's lasting impact on the court is that everyone, including Elena Kagan, is now a textualist. I mean, everybody concedes that you have to look at the text of the statute, and it matters what the statute was understood to mean at the time that it was enacted. I think some of the justices feel like they can give that a tip of the hat before they walk away from it. Others are actually wedded to it, but it's a factor in every single case, no matter what. So in the more freewheeling days of the court, when they kind of figured out where they wanted to come out and then reasoned backwards, Justice Thurgood Marshall wrote a case called Anderson. I think the year is 1964. But they applied the statute to not a context of violence, but ballot stuffing. And I don't think this was the first time that the statute had been extended beyond the realm of violence, but I think it was the first time that the Supreme Court stamped the idea that you could take it beyond what it was originally designed to prohibit. And interestingly, what Marshall says there is a couple of things. One is that there's a right to vote, which really there's not. The Constitution doesn't give you a right to vote. It puts the states in charge of that. All states have had a popular vote for over a century now. And certainly there's an equal protection clause. So if a state extends the right to vote, everybody has to have equal access to it. But there's actually not a constitutional right to vote. But what he also interestingly says is something I think that progressives would reject today, which is that the reason that ballot stuffing is cognizable under the civil rights statute is every American's right to vote is precious. And if you let the ballot box be invaded by either people who don't have a right to vote or people who don't actually exist where the ballots have been put in, that dilutes everybody. Everybody who has a legitimate vote is injured because injured, by the way, is the word that they draw from the statute here. You're all injured because your right to vote has been diluted to the extent that they have people who are ineligible or ballots that are ineligible that are counted. I think if you told a progressive today that, we can't let undocumented migrants vote because that would dilute the votes of, legitimate American voters, that probably is not an argument that would fly much. But this is the argument that was made in the Anderson case. So the question is, how far out of its original context is the court going to allow the civil rights statute to be drawn? And what I think they can say and will say is that we wouldn't have come out the same way Justice Marshall did on the ballot stuffing case because it's too far removed from what the original understanding of this provision was. But even if we just let that precedent stand because it's not before us and we don't need to revisit it, this is a step even beyond that, because at least Marshall's case dealt with the act of voting. The ballot box is diluted, and the people's the voters' ballots are therefore diluted to the extent that you have invalid ballots. Whereas what's happening here is the act of voting and everything with it is done. It's over. And what Trump is trying to do is get legislatures and courts and election officials to reverse the result of the election. So I think what they're going to end up saying is that, maybe somebody ought to make that a crime, but that's very far afield from what that statute meant when it was enacted, and even beyond what it's been extended to.
Okay, so the pushback on that is that there are oodles of cases using this civil rights statute and the precedents that followed from it that have been brought before the court, it has been tried, and people have been convicted on all sorts of cases that have nothing to do with the violent stuff, right? So like there's a sort of large amount of stare decisis here that you are accused of eliding to make an originals point, which I think the originals point is perfectly valid on its face. And while I think the hypocrisy of how progressives talk about voting is always fun to point out, I don't think it's necessarily germane to whether or not.
You're right. That's right.
A court is going to look at this, right? Or how a court is going to look at it. And again, bad cases make for bad law, and we are in new frontiers on all this stuff because of what Trump has done. Again, I place the onus on what Trump has done more than what Jack Smith is doing here. I would rather Jack Smith not be the guy with the broom behind the elephant on this. I think that should have been caught earlier in the process, but this is the world we have. And so it seems to me a perfectly colorable argument to say millions more people voted for Joe Biden lawfully. And there's no evidence of the kind of mass fraud that could have changed the outcome of the election. The president was informed about this by all the reliable parties, and he kept shopping for more and more crazy people to tell him what he wanted to hear. And he pressed ahead to say, let's just throw this election out. If I'm on a jury, and like I'll listen to the nice lawyers argue about stuff, but that sounds like a plausible argument to me. Why is that wrong? I mean, like I get the point again is sort of like, if we have no choice but to essentially make law here because of what Trump has forced upon the system, is this a reasonable interpretation of the law as practiced, not just in the original writing of it, but up through recent court cases on all sorts of things, that says if you lie and cheat and obstruct and conspire to undo a proper election, that's a crime. I mean, I don't see why it's so controversial to you and my friends at NR.
Well, I guess it's because there's a difference between the act of voting and what I think this was, which was based in bad faith, to be sure, but a post facto attempt to get the election overturned, which is not the same thing as injuring the act of voting.
Okay, so what if Donald Trump had suborned, encouraged, cajoled, lobbied various officials to simply burn a bunch of ballots that came from predominantly pro-Biden districts? Would that be a crime?
Under Marshall's interpretation of the law, which has been applied, in, as you say, in various different iterations, sure.
But so that once the votes get because in effect, what the ratification, certification, whatever you want to call it, process, basically what that is there's like a box brought with the electoral votes in it, and they say this guy got more than this guy, so this guy's the winner. Simply by virtue of the fact that it got to that stage in the sausage making, you can't then say it's a crime?
Here's what I think the difference is, Jonah. What you're talking about is a situation, and this is where the law has been applied, to make the popular vote look like something it wasn't, to change the outcome of it. That's not what happened here. What he's saying is that the popular vote is what it is, but because there was all kinds of instances of fraud, we want the process to reverse it and supplant the legislature's vote for the popular vote. To me, that's a different thing. And what I think is that the Supreme Court, asked to look at that, would say, all right, well, first of all, what was the statute intended to do in the first place? So they would go back to the original meaning of it. And then they would say, to the extent that this has been teased out, even if it's beyond what we are comfortable, what is the principle that we can stand that actually is somewhat rooted in what the original purpose of the statute was? And I think that goes to undermining may be the wrong word because it's not precise enough, but a distinction between the act of voting so that the popular vote is misrepresented in terms of what it actually was, which is what ballot box stuffing does, which is what burning ballots would do, which is what the stuff that the Ku Klux Klan was targeted over would do, versus you have the popular vote, and I'm now going to state courts, state election officials, and state legislatures and arguing that they should overturn the popular vote because the contest lacked integrity for X, Y, and Z reasons. I think that's. I just think that's a
different thing. I take your point. I mean, so it's funny. Our mutual friend Charlie Cook, he's got, because he's such a quirky guy, one of the things that he's got a bee in his bonnet about is he thinks it was terrible that the government went after Al Capone on tax evasion because they couldn't get him on murder.
Right.
I want to be really clear about this. I do not lose a scintilla of sleep over this fact. And while I would love to have the argument over drinks with Charlie, it seems to me that given what Trump tried to do, which I think we both agree is just nakedly transparent in the indictment, and also was nakedly transparent at sort of the time. I mean, they planned to lie about the election results.
Yeah, I thought this is interesting because reading over the indictment again today, Smith says that the conspiracy began like right after the election.
I don't believe that.
And so I always thought, now I have to go back and look at this because this was too close to when we were going to talk that I could go back but I seem to recall there was something about Bannon saying like weeks before the election that what Trump's plan was just to say it was a fraud.
Mother Jones got hold of tapes where he's saying to a bunch of people, it's going to be amazing. It was like in October before the election. And he's saying, it's going to be amazing. He's just going to come out and say, I didn't win. I mean, I didn't lose. I'm still president and try and get me out of here. And
now maybe what Smith thinks is that was Bannon talking off the top of his head, not saying something Trump had told him was, but I have to say, I was surprised when I read that today that he was saying that it started after the election.
Yeah, and it's also entirely possible that he's got inside testimony that supports that narrative more, even though you could point to things that say this plan was inevitable because people have been talking about it for a long time. I mean, Trump in 2016 said, if I don't win, it's because the system was rigged, right? I mean, this has been a go-to thing for him for a very, very long time. All right, so I've kept you long, but I there's a question I've been meaning to ask you for a long time. And if you don't want to get into it, I totally understand. But it's a theme that I revisit from time to time of who was always crazy and we didn't know it, and who went crazy because of the hothouse environment of the Trump years. I grew up in New York City. I was a huge fan of Rudy Giuliani for a long time. I think he did, as mayor, some great things. And he's gone a different way. I think that's fair to say. And I know it's a personal thing for you. So if you don't want to get into it, you don't have to. But like, what is your theory? You know, when people ask you, and I'm sure they ask you all the time, what the hell happened to Rudy? What do you say? Like, what the hell happened to Rudy?
I don't want to get detailed about it, but I think his personal life, he had a lot of hijinks in his personal life. And I think that's a huge part of it.
Okay, fair enough. John Eastman. Do you have a theory about John? I mean, here's an easier one, I think. Sidney Powell. Like when I first heard Sidney Powell's name, she was like a serious, prosecutor, lawyer type. How do you get to that from there to Italians? The Italian embassy ran satellites that stole the election.
I'm glad that you ask it in a group, because it's a lot easier for me to take on that way. I have thought for a long time, and this is a little hard for me because Trump just doesn't have this, he doesn't make me go crazy, but I've never I didn't want to go to the government and work for him. I never felt any hesitancy about where I thought he was 100% wrong about something, saying that. I wrote something, that went wild when he insulted Jim Comey in front of the Russian ambassadors, because I thought that was like one of the lowest things you could. So I try not to make anybody else's fight my fight, because I seem to attract enough of them on my own. but I also, but I also, like with this guy, I haven't. What I've stood back and sort of in wonder at people who I know were like 5-alarm anti-Trumpers during the 2016 nomination contest, who've like gone 180 degrees the other way. And if you showed them the things they said and wrote in like 2015, 2016, they would deny it like St. Peter. I mean, they just they're like mentally in a different place. And I have always felt like Trump has a strength of or a shrewdness of being able to read in people what their seemingly petty resentments are. And I would say in a big category of people, that you have a lot of people who think they've always been the smartest guy in the room and no one ever noticed it before. And then he kind of batted his eyes at them and they were his. And I think a lot of people go into this category. I think they're just at a certain point. It seems to me like the thing with Trump, the bright line is fealty, right? So if you jump on that bandwagon, that's what it's about. And the people who have jumped on with both feet, they bought onto the fealty thing. I mean, when you talk to them, they talk about him like they don't talk about anyone else. On the other hand, just like to say that I'm not immune from this sort of thing by any means. I thought that, back when, I thought you and Kevin and David were crazy to be worried about him, because I was totally convinced, the same way I'm totally convinced, which is why you always have to remain humble that you could be wrong about stuff, right? The same way I argued to you that I'm sure that this is the way the fraud statutes will come out, I was sure that Trump wasn't serious about running. And I thought this was just something he was doing, and he'd get tired of it at a certain point. And once the brand was pumped up to whatever he was trying to do, he'd get out. And he didn't. And then I thought, when it got around to the 2016 election, I was one of the people who argued that this is a two-choice process. It's one or the other. And with all the people who said, no, it's never that, you can always do. I said, in the jury system, in the criminal justice system, we put 12 people in a box. And sometimes it's a really bad crime and the government's case sucks. I mean, I've been in a few of those where the FBI did all kinds of awful things in the investigation, but the guy's a really bad guy, like he's a murderer or whatever. And the jury hates the case because no matter how you go, it's terrible. And we don't tell them, they get to say, nah, I can't decide. It's like, it's two lousy choices. and you have to pick one or the other. And I just thought people who were saying that I'll never vote for Trump, but that doesn't mean I'm voting for Hillary. I'm like, well, if you're not voting for Trump, then you're effectively voting for Hillary. It may be just half a vote rather than a full vote, but that's what you're doing. And here I am, 4 years later, I guess now 8 years later, and I think Trump should have been impeached, convicted, and disqualified. How on earth could I ever support somebody who I think should have been disqualified in the in the constitutional process? And I said this after the 2020 election. We wrote this thing at NR where I was yes, Ramesh was no, and Charlie was maybe, right, on Trump. And I ended up writing afterwards that Ramesh was right and I was wrong. I mean, because I'm not, I don't let people off the hook for this kind of stuff. So I can't let myself off the hook with this kind of stuff. What Trump did from election day 2020 to beyond the Capitol riot, and continues to do in the way that he denies what happened, it's not like that was a revelation. Like if somebody had told you in 2018 Trump was going to do something like that, if somebody had told me that, even after I voted for him, and not only voted for him the second time, but also said, you're much better off with a Republican administration, even if you have to take this guy, than you would be with Biden. I can't say that if somebody told me in 2016 or 2018 that Trump would pull what he did in 2020, that I'd be like shocked beyond belief. So I can't say that this guy he's not, that what he is now is something that he suddenly became. I think this is who he was all along. And I have to live with the fact that, I signed off on it twice. Now I have a lot of, I can make a lot of good reasons, I suppose, why I did, but I did what I did. Right. But at this point, and this goes to like what we were talking about before about the wall and all the things you passionately say, this is how it is. And then it turns out that you didn't think it through enough and you were wrong. Here I am in 2024. I'm in the same place that people were in 2016, where they said, I'm not voting for this. There's nothing that would happen that would get me to vote for this guy. So, when I'm thinking about Rudy and I'm thinking about Sidney and I'm thinking about Eastman and all these guys, I'm not saying what I'm going through is anywhere near that same category, but I think a little humility is in order.
Yeah, I mean, again, look, I mean, I didn't mean to force you into a rigorous personal inventory over the last, 7 years, but look, I mean, and I know I'm going to get grief for having you on and having a civil conversation about this stuff and all that. But I've said this a million times on this podcast, and I say it to people all the time, is like, the thing about Andy is he can get worked up in sort of partisan zeal, but he will never go beyond where he thinks the facts will take him. And that's true of a lot of us, right? We can get worked up on things, and the problem, and this is why, look, I mean, like, what's his name? The guy, Pope Hat, Ken White. Yeah, Ken White. He has this searing attack on you and NR that I think would have been well served for him to sort of keep the substance and cut out all of the ad hominem, because it's he's just like, you're deliberately lying and all this kind of stuff. And it's just like, I know how the sausage gets made at NR, and I know you personally, and like, I am not fully equipped to adjudicate a lot of these legal questions, but I know you're coming at this in good faith. The problem I have with the Trump era more broadly, and about some of these kinds of characters and a lot of the apologists, is that good faith is in short supply in a lot of places, right? And so I can, I can disagree. It's not like, I disagreed with you and Charlie in that thing because I thought it was sort of a cut and dried kind of thing. I disagree with you about the binary vote thing, in part because I live in Washington, D.C., and I've never lived anywhere where my vote wasn't canceled out at least 7-1. So I really just don't give a rat's ass about my vote in this sort of strategic kind of sense. But I know you guys are coming at it from a good place, or from a patriotic, good faith, intellectually honest kind of place. But intellectual honesty in a lot of quarters, I mean, when And I know you don't want to get back to Rudy, but like when Rudy says, we have lots of theory, but we're really short on facts. That's a problem. And I find that so much of our politics these days on the left and the right is with people who have a really short supply of facts, but are really passionate about their theories. And that's very frustrating to deal with.
Yeah, no, look, well said. It is what it is, though.
All right, my friend. I got to get you. I guarantee you the first criticism. So I'm going to get criticism from the lefties who listen to me, and the more ardent anti-Trumpers for one set of things, and then all of my righty friends are going to be like, "How could you have Andy McCarthy on for 90 minutes and not talk about Hunter Biden and Joe Biden and all that kind of stuff?" So I'm going to need to have you back on for equal time. Okay.
Anytime.
All right, Andy McCarthy of National Review and many other things. Thank you for coming on the Remnant.
Jonah, thanks for having me. Appreciate it.
Okay, so Andy McCarthy has left the studio, and I fully, as I intimated, I fully anticipate some colorful and passionate responses from various quarters, which is all fine and dandy. I think I was very clear in stating my priors. Andy's a friend. I think Andy's an honest and decent guy and doesn't deserve some of the grief he gets. And I also think he's a grown-up who can handle the grief he gets, so I'm not like worried about him in that sort of sense. We'll put some stuff in the show notes. Ilya Soman, the guys at Lawfare, and Ken White, who I'm a fan of, but I think is a little too intemperate and assumes and is asserting bad faith unfairly. They make strong cases going the other way that the fraud statute stuff that Andy is making too clear cut and black and white an argument about something that is at least equivocal and ambiguous. That said, if you listen to AO, Sarah and David, while they disagree with the sort of the fraud, this very specific granular fraud statute stuff, they agree with Andy that these are going to be, this is not an easy lift for Jack Smith for all sorts of reasons. These are complicated arguments to make, where they're going to be a gazillion motions gumming up the works. And it's not like we didn't even talk. I don't think we mentioned it, but we didn't talk at all about the Mar-a-Lago case. The Mar-a-Lago case, I think, is cut and dried. And I'm very confident in saying it is obvious that Donald Trump is guilty, flat out. And that lots of people have been convicted for doing less than what he did. And one of the reasons why I think it's obvious that Donald Trump is guilty is that he has not yet made an argument that is even colorable, that is even sort of entertainable, that gives him an excuse for that he didn't do it or that he didn't break the law. And the fact that Donald Trump keeps changing his explanations and his excuses and his arguments almost on a day-to-day basis suggests that he's guilty, right? I mean, if one of the great rules in Washington is if you get caught up in a legal, controversy or scandal or political firestorm, if you did nothing wrong, then you can always just tell the truth. And it's easy to remember the truth. It's really hard to keep track of all the lies if you're trying to wiggle out of stuff. Donald Trump is obviously lying on the Mar-a-Lago stuff. And as a political strategy, it might have been better for Smith just to bring that case. I don't know. I think Andy is right that there's an enormous amount of institutional and political pressure to want to hold Donald Trump accountable for the things he did leading up to January 6th. And I'm just much more sympathetic than Andy is about trying to hold him accountable for the things he did leading up to January 6th. I think that in the abstract and maybe in some specific circumstances, Andy is certainly right that it would be better if the law were clear cut. And it would certainly be better if Jack Smith had the evidence and the facts to go straight up at Trump for the fomenting and encouraging violence, even though that's also a very fraught approach, because then you could get into like the First Amendment stuff and all that. But clearly Jack Smith doesn't think he has the facts and the law and the evidence to do that. So he's doing this. And I get that Andy's a stickler about how the Justice Department and the rule of law should operate and criminal procedure should operate. And I agree with him under normal circumstances. But Trump is the father of abnormal circumstances in this context. And I have zero sympathy for him if the institutions that he has made war on rhetorically or otherwise, including legally and politically, are responding to the trouble that he went looking for over and over again over 4 years and continues to go looking for now. It would not shock me in the slightest if Donald Trump gets into enormous trouble simply because he can't stop himself from attacking the prosecutor, cannot stop himself from intimidating witnesses. And even if all the underlying crimes were thrown out for the reasons that Andy says, it would not bother me a whit if Donald Trump got convicted simply for witness tampering or witness intimidation or any of those kinds of things that were just in response to being prosecuted in the first place. I'm on team put Al Capone in jail. And if that bothers people, so be it. But that's sort of where I come down. And I'm going to leave it for my friends at AO to get into the weeds on some of this, whether USC blah, blah, blah is more relevant than USC whatchamacallit. And that's all fine. So with that, thank you all for listening. And I'll spare you all the announcement stuff for the next podcast. And I'll just see you next time.
No, you won't. This is a podcast.